Ordinance.
Hi, thank you for joining us for another installment of California Employment News, Weintraub's L&E podcast. I'm Shauna Correia, and I'm the practice group leader of the Labor and Employment Group at Weintraub, and I'm joined today by my colleague, Meagan Bainbridge, who's also a shareholder in our group. Today, we're talking about a recent amendment to the San Francisco Fair Chance Ordinance. San Francisco was a pioneer in 2014 in the national ban the box movement, enacting statutes that provide for protections for employees or applicants with respect to background checks. And on August 10th, 2026, newly approved amendments took effect to San Francisco's Fair Chance Ordinance, expanding some of those protections for job applicants and employees. This is San Francisco's effort to protect city residents who may have had convictions under other state laws that would not be violations of California law or city ordinances. So, Meagan, could you remind us the scope of the San Francisco Fair Chance Ordinance?
So the ordinance applies to any employer that is located in or doing business in the city and that has 5 or more employees worldwide. Note, this includes all employees, even its owners. It applies to all types of employment, including through a temporary agency, and covers employees who work at least 8 hours per week in the city and applicants for prospective employment who work at least 8 hours per week in the city.
Does this include remote workers?
Yeah, it covers employees who would work remotely from any location in the city. But it should be noticed that it excludes government agency employers. So we're really looking at more the private employer side. Shauna, what's the key change to the scope of the FCO?
So the biggest change is that San Francisco employers now cannot inquire about, consider, or rely on out-of-state arrests or convictions when they're making adverse employment or hiring decisions, if that conviction or arrest was for conduct that would be fully legal under California law. That list now expressly includes convictions related to abortion-related health care, gender-affirming care, drag performances, spontaneous abortions, and stillbirths. And it can include, for example, things like marijuana-related convictions that would not otherwise violate California law.
Right. And it's important to note that while California law gives employers some discretion to evaluate whether an applicant's criminal record directly impacts their ability to perform their job duties, the San Francisco ordinance now states that criminal records falling under these categories can never be deemed directly related convictions.
Exactly. However, of course, a city ordinance can't preempt state law. So if there's a statute, for example, in the education code, that would disqualify an employee for certain types of convictions, the Fair Chance Ordinance can't override that. My recent blog post covers some of the more technical and procedural requirements, so we encourage employers to go and read that. But Meagan, can you give employers a couple of key steps that they should take now before posting another job ad in San Francisco?
Yes, so effective immediately, hiring managers should add to the new notice language to all job posts targeted at applicants who are reasonably likely to seek employment in the city. Also, hiring managers will need to comply with the new timeline for adverse action notices and post the Fair Chance Ordinance at their workplace.
Thanks, Meagan. That's all we have time for today, but Weintraub L&E attorneys are here to help companies with their background check procedures to avoid possible administrative fines. Subscribe to California Employment News to stay up to date. You can also find more information about this and other employment law updates at www.thelelawblog.com. Thanks so much.